May I please?
Yes.
Tell that one. Madam, just come up day before yesterday.
Since 30th June, my lord, there was a stay ongoing in my favor. In this application, I have also produced from record that how the council had acted against the advice of the client, but be that as it may, my lord, I must also...
1 second.
It is
That's it.
Acha, this is that matter.
that bad.
You are Mr.
I
Karla.
am Mr. Kalga, my lord. The instruction to the council on that day was to simply take a passover, my lord. I put that on record with screenshots. It was not for an adjournment in any manner.
But that was not done before.
That was
this
not
court.
done, my lord. But what I'm trying to say is, therefore, I'm just
It
trying
was
to...
made a specific, averment was made, a specific statement was made before this court that you are unable to attend the proceedings of the court because of a health issue.
Yes, my lord, I was unwell. I was going through some medical tests. Therefore,
So there was no request for passover for
That
the
was
time being.
That's what
Yes.
I'm trying to...
Anyway, what
Yes.
has happened, Mr. Karla. Now,
Yes,
why
my lord,
is this matter
it is my
listed today?
responsibility to clean the air.
That's all right. Yes.
So therefore, my lord, what has happened is, on that day, for whatever reason, the interim order was vacated, my lord. And I can show from the record that it was the government which sought adjournment at least 3 times.
Mr.
After-
Karla, we are not on the adjournments. Why is
As I
this
said,
matter
it
come
is-
up today? Is this matter for admission
No,
today?
this matters for final arguments, my lord.
For
Final arguments, my lord. I am ready to argue.
this matter is fixed for hearing.
My matter is fixed for hearing, my lord.
No, it's at the admission column. That matter has not been admitted.
My lords, on the last date,
Is there an order for hearing?
on the last date, it was fixed for final arguments, my lord. Kindly see the order prior to the last one.
That was the understanding, Lordship, for final disposal.
For final disposal.
We are ready for any
What,
time, Lord.
what has
Okay.
happened is this.
All right, then we proceed with the impression that we are finally hearing the matter. Then
Very well, my lord. But there is one development which I wanted to just bring to my lord's kind attention. That day we requested for 10th, my lord. Government did not agree, my lord. They agreed for today. Yesterday they issue a notice, my lord. Surprisingly, I am reading, my lord. Kindly have this one word. The notice on the top right is dated 10th September 2025. That is yesterday, my lord. The first paragraph is as under: the first provisional merit list for the post of assistant teachers of lower primary school and assistant teachers, which I am claiming a right upon, under the Directorate of Elementary Education, will be published in the official website of so-and-so from midnight of 10/9/2025. So, my lord,
earlier the stay was for not publishing the provisional list.
yes,
That was the effect of this.
that was the effect, my lord. But knowing that this honorable court is seized with the matter, knowing that the matter is listed today,
Can we come back to the order of? Please place the order of 36, 2025.
30th June, my lord.
Yes, let us see that order one.
Indeed, my lord.
That was the order on which the notice was issued, right?
Notice was issued. Government
And
was-
you had challenged, what is this notification?
Yes.
17/6/25?
Can I just give a brief back?
Yes, please.
Look, we are candidates who wanted to be government teachers in primary school, my lord. There was some confusion with respect to our eligibility because we did a Government of India course from NIOS.
You are what students, you said?
We are candidates
For computer?
for assistant teachers in primary schools.
Assistant.
Assistant teachers in primary schools, Government of Assam.
Yes.
We have done our diploma from one institute, NIOS, under the Government of India scheme. There was some modification brought upon in RTE Act, Right to Education Act in 2015, which said that whichever teacher is in service in private school, etc., needs to take the minimum eligibility qualification as per the NCT, National Council of Teachers Education. That is the council regulating all the mandate for we as teachers, what should we get? So an amendment was brought in 2015 by the Government of India, saying that whichever teacher like us are in service in private schools need to take the minimum qualification, which is a diploma in elementary education. In short, D.El.Ed. D.E.L.E.D. Diploma in Elementary Education, by April 2019. This was an amendment that was brought. Therefore, the Government of India in 2017 brought about a scheme saying that we, the people who are already in service, can take this online diploma from an institute recognized by NCT called NIOS, National Institute of Open School. So we are all those people. We took our course from there.
From an open university.
From an open university under the Government of India scheme, one-time scheme by the MHRD, Government of India, NCT, all recognized together. All those communications I will take.
And this is as per that OM.
This is as per that OM, Lord. Introduced by
Which
MHRD.
page is that, OM?
Lord, I'll just show you.
Just give me the page.
Yes.
We'll go
Yes, I will just
later
take you
into the depth of the matter,
Yes,
but I'll just indicate me the page number.
Yes, my lord will just have, there are two things. One is a writ petition and the other is a convenience compilation that we had filed before the Honorable Supreme Court, because this matter
Which
comes.
is that?
So one is a writ petition and the
Which
other
is that compilation?
It's
This fat volume.
Yes, the fat volume. With the heading is second volume convenience compilation of pertinent acts.
Not this one. This is the writ petition.
Yes, other than that, there will be a convenience compilation, my lord. That we have given.
Compilation asani.
Can you just show this to them? It says in the Honorable Supreme.
You have a copy?
Yes, sir. We had given it on the first day, my lord. It is like this. Yeah, it says in the Honorable Supreme Court of India. It is like this.
It's okay. It's okay. You stay there.
No,
Give the file to them. Give the file. Mr. Chesty. Again, just take out whatever you want to. No, it may be there. Just take it out from there.
It is like extra. Give it to you.
Otherwise, give a copy if it is not there.
You can use it.
If the earlier copy is there, you can give it. It's there. Ek on grade look.
I take, my lord, to each and every page.
So I take it that now I don't have to hold that volume and we can deal
Yes,
with
my
this
lord,
volume,
this
huh?
is-
Mr. Sakya?
Yes, I agree with you.
Apart from this, my lord, there's only two orders of the Honorable Supreme Court which are there.
Okay.
Now, just let me, if my lord would permit, just the narration of fact for giving a brief
Yes.
background of the matter. So therefore, this one-time courts brought in for the entire country, my lord. There were teachers from across all states who were working as on 10th August 2017, 8 years back. One-time opportunity brought in by the government of India because of an amendment made to the RTE Act. That time, my lord, the responsibility, or I would say the ignition, to identify the in-service teachers, as in who were working, was cast upon each state, all the states across the country. The NCT, the MHRD, through these notifications and through these communications, which I will show, told each state, the education secretary, etc., that please identify the in-service teachers from your state. Give us the names of all these in-service teachers. And after that, once you confirm the name that yes, so-and-so is in service, then we will let them do this course. This was the arrangement made that time. So everything was state-based. State would give the name, state would have coordinators, and then a person would be eligible to take the course. 2019, we completed the course. Thereafter, there were two recruitments in 2019, 21, etc., where because we completed the course in 18 months. 18 months was through the online portal and 6 months internship because we were already working. The NCT said that the course should be done in 24 months. That is the normal rule.
And you did it in 12 months.
18 months.
18
months, because the time duration I will show from the documents was such that those
But are those things an issue?
No, I will. But it is important for my lord to understand the background, that because it goes to the Supreme Court, then it comes back. So why did it go to the Supreme Court is important.
No, but otherwise, I'm hearing you, so you can argue for days, no problem. But just indicate
Please.
what is the issue involved in this
The issue is
petition.
this.
It would be easier for the court to appreciate your arguments then.
Yes.
What is the issue?
The issue
What
is
is
this.
your grievance and why have you filed this writ
Yes,
petition?
the issue is this. There was some confusion with respect to whether we will be eligible or at par with the normal degree holders or not.
Okay.
Every state was misreading a Supreme Court judgment of Uttarakhand, saying that we, 18 months holders, will not be equivalent to 24 months.
Okay.
Supreme Court then in December 24 clarified that we are equivalent to the 24-month holders. Supreme Court
So
clarified.
in that OM, the time was given, 24 months.
Yes, 18 and
Since you completed it before the 24 months,
Yes.
therefore that controversy came
Controversy
whether
came.
you are eligible or not.
yes, controversy
Since
came
you
in for one
completed,
state.
since you completed
Yes, exactly.
within
Exactly.
18 months.
Exactly.
Yes.
So controversy came for one state.
This controversy was put to rest.
Was put to rest, saying that we are equivalent. Prior to the controversy,
This was by Apex Court.
Apex Court in 23. The controversy started in 23. So we completed the course in 19. From 19 to 23, the state has recruited people like us. 23, the controversy came. From 23 to 24, December 24, the controversy continued because there were some reviews, clarifications pending in Supreme. December 24, the Supreme Court clarified that we are equivalent to the 24-month holder, but there were two conditions. The conditions were in the order which I will show, that we should have completed a diploma within that April 2019, plus we should have been in service as on 10th August 2017. These were the two things Supreme Court says that yes, if a person has completed the diploma within the 20 period and is in service as on 10th August 17, they are at par. Then Supreme Court implements its own clarification for 3 states. One being Uttarakhand, I will show those orders also, West Bengal and BTR. All these 3 cases I had the opportunity to assist the Honorable Supreme Court. Implement saying that yes, please, they are eligible, give them appointment. The advertisement, which is the subject advertisement, came in December 23, 26 December 23. The advertisement was ongoing. The present advertisement, which had 5,500 posts. There were writ petitions filed before this court that because Supreme Court has given a clarification, please implement the same for us.
In the advertisement, it says 24 months.
In the advertisement, it originally said nothing, but later on there was a circular saying that we are not eligible, relying upon the earlier Supreme Court judgment. So therefore, that circular was challenged in the writ petition saying that no, we have to be considered equal only and you can't treat us not at par with the regular ones. Supreme Court clarified. Writ petition was modified. I had the opportunity to argue one of those writ petitions. Writ petition allowed in terms of Supreme Court order, we are at par. Then the process for these 5,500 vacancy proceeds ahead. Now this impugned circular comes in, my lord, where 9 documents have been asked to prove my in-service capacity. 9 documents which were not required in 2017, where I was not the one to show that I am in service, the state was the one. And 9 of these documents have been shown, say that if you give these 9 documents, only then will we consider you in service. And therefore, I filed this writ petition that boss, first the responsibility, the first moot question for my lord's kind consideration on 30th June when I argued was that whether to be in service is my responsibility or the state's responsibility, as per the documents, as per 2017.
Is this matter a part-heard matter?
No, it is not really a
Then
part.
you said that when you argued on such and such date.
No,
So,
on the day of notice.
so now we are
On the day of
hearing.
notice.
So let us concentrate
Yes, yes.
from today.
Yes, yes.
Yes.
The point that I am trying to make is this.
Yes.
As on the notification that came in, my lord, which said that all you in-service people give these 8 documents. We are those NIOS.
So basically in this read, you are challenging the circular
saying
whereby you are asked to submit 9 documents
to prove my in-service
your
capacity.
in-service capacity.
That's the short.
And earlier, it appears that it was the state
Yes.
who had to do it.
Yes, it was the state always which had to do it. State in their counter to the present writ petition saying
And which page is that Supreme Court decision whereby this 18 months have been allowed?
yes, my lord would
Let's
kindly
go to
have
that, please.
the fat volume. Sorry, now the fat volume. Will have, please.
You don't have to be sorry. Yes.
Please see 567.
Page
567.
567.
Yes. Annex 4. In this Supreme Court decision, State of Assam was a party.
Yes. Review petition.
These are review petitions and miscellaneous applications, my lord.
Yes.
The relevant, my lord, would see at 568.
Yes.
Kindly have para 2. We have already clarified in the judgment, may I read?
Yes, yes.
We have already clarified in the judgment under review that the one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10 August 2017. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. However, third is important. To avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in the other institutions or for promotional avenues.
So these documents which they are now seeking are in connection to show that you are in employment as on 10/8/2017.
Indeed, my lord.
That
Indeed,
is
indeed,
that those documents.
Indeed.
Then what is wrong in those documents? That
The
circular?
wrongness is this, my lord. As I said, 2 questions. First moot question is whether I was in service on 10th August 2017 or not was the duty cast upon state at that time. So it was the state to verify. If the state wouldn't have.
But suppose the state is not, now the state wants you to show that. What is
Yes.
the wrong? How are you prejudiced?
Yes, I am answering that, Lord. That is number one. Number two, my lord, the documents at that time that was asked to show whether I was in service or not was an experience letter from the principal. That was the only document asked for.
When earlier?
In 10th August 2017, as per the Government of India circular and the approval recognition order that came in. Only one thing.
Now they are.
I am producing.
Now they want 9.
They want 9. I am ready to produce that one document.
And what are these 9 documents?
These 9 documents, my lord, directly please come to the impugned notification at page 54.
Of the compilation or
Of the same writ, my lord.
page?
54. The problem is this, my lord, that most of these schools have shut. I'm sorry.
Yes.
Page 54, my lord would see the notification which is impugned herein. It gives the heading of in view of the judgment of Honorable Supreme Court dated so and so. This was the order we were just reading, my lord. So they derive that from this Supreme Court order we are bringing in the following documents. So and so against advertisement are hereby asked to attend the second phase of physical document verification in due course of time when notified with.
So you've been asked to attend the second phase of physical document verification.
Indeed, my lord.
With the following documents.
Yes.
Yes. Which are these
The
documents? now?
first is, my lord, appointment letter and accepted joining report of the applicant, which I'm not okay with, my lord, because I was never asked at that time.
But you don't have an appointment letter?
My lord, we only have an experience certificate, most of us. All of these are private school, my lords, where what was required at that
You
time.
don't have an appointment letter.
Some of us don't, my lord. Some of us only have an experience certificate because
How? How will
look, what happens is most of these schools, because we were not in government schools, my lord.
How
we were
can
in
that
private-
be?
But government schools, if we
See, even if something has happened, you want the court to now perpetuate an illegality.
no, my lord, that is
How can you? Anyway, we will come to all
I'm
that
on a
later.
different footing altogether.
All right, Mr. Kala, let's go on.
I am on a constitutional bench judgment which says that the rules of the game cannot be changed.
So I'm not on the rules of the game because now it seems that you have there is a judgment of the apex court which says that the 18 months, as far the 18 months is concerned,
Yes.
to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017
Yes.
and who have completed the diploma course of 18 months
Yes.
would be treated as valid diploma holder.
Yes.
Now the question is whether you have you were in employment as on 10/8/2017, number 1.
Yes.
Number 2, whether you have completed the diploma course in 18 months.
Yes. Yes.
These are the two questions
These are the two
before
questions.
you are taken as
A teacher.
as a valid diploma holder, as a
Indeed.
valid diploma
Indeed.
holder, right? Unless you have 24.
Indeed.
So now for that they have come out with a circular
Yes.
that these are the documents we need in
Yes.
terms of this order.
Yes.
So what is wrong? That is you have to satisfy.
Yes.
I have not made up my mind.
No, no,
I am yet to
I-
hear the other side. But
every endeavor
you
to
see,
satisfy.
these are the queries that are coming, and I am only sharing it with you so that you
I'll
can
address-
accordingly
I will address all of them, my lord.
correct.
Rest
Only
assured.
for that purpose.
I am rest assured.
Yes.
So the first thing that they ask me is appointment letter and accepted joining report of the applicant. I have a problem with this. Second thing they ask me is minutes of school management committee of the school in respect of the appointment of the applicant concerned. My lord would make a mention here. Most of us were in rural schools. We are still paid salary in cash of say 3,000, 2,000 a month. There is absolutely no school managing committee in such schools. Then please see 3. Photocopy of the attendance register of the school during the service period of the applicant duly countersigned by the head of the institutions. Fourth is very important, my lord. Certificate issued by school authority specifying the service of applicant in this school as on 10th August 17, which all of us have. This is what was required at that time. Then please see salary statement stating that the pay band, basic pay, DA and other allowances of the applicant of the entire.
This also you have a problem.
Well, I am given, yes, I have a problem because I am given salary in cash. There is absolutely no basic pay DA that I get. And if they would have asked me for these things on 10th August 17, I understand, my lord, I have a right to satisfy them. 8 years later, my lord, someone turning back and saying that because you need to prove when the Supreme Court order later, we just read one order, my lord. There are 2 more judgments where the Supreme Court is clarifying its own judgment further. I'll show that for Uttarakhand and West Bengal. There is no mention of these documents. Nothing. Zero. I will show that. It is all part of my writ petition. So therefore, the second last document, salary statements, I am getting my salary even today in cash. 2,000, 3,000 rupees a month I get. There is absolutely no concept of pay band, basic pay.
Where are the averments in relation to this?
Yes, I will show that, my lord. I will show it from the writ petitions. Then please see the last one, which is most important. UDICE records as a proof that the applicant was in service as on 10th August 17, my lord. UDICE, my lord, would note is the full form of UDICE is Unified District Information System for Education.
Unified
District Information System for Education.
System
For Education.
for education.
To put it in plain words, bro, this is like an Aadhaar card for a school. That every school will have a unique UDICE code. Even till today, my lord, forget 2017, even till 2025, the government of Assam has not made it mandatory. Even till 25. So therefore, asking for a UDICE code of 2017 of a school, my lord, which is not even made mandatory in the state till today. Where is the source of power for any of these documents? And I go back to my first argument, my lord. The source of power needs to be seen because ultimately it's a recruitment. They are bound by NCT regulations. NCT has not asked me for any of these documents. Government is simply bound by the NCT regulation. I will show NCT has to prescribe the minimum qualification.
Where is that 24 months requirement?
In the NCT, my lord. The NCT prescribed that any assistant teacher for primary school will have to have a 24-month diploma. That is, they say 2 academic year. In fact,
You don't have 24 months, you have 18 months.
well, yes, that is the confusion that was created.
And that was clarified by
Yes,
the
NCT says 2 academic years, and Supreme Court clarifies that yes, this will be considered as 2 academic year. Why was it 18 months? Is also the government of India specifying. And this is not just me, my lord.
Various.
14 lakhs of people like me across the country have done it. 14 lakhs.
This 24 months figures which page in
NCT, my lord.
NCT, na?
Yes, it says 2 academics here. I will just show that from the compilation.
Just give me the pages.
Yes, I will just take my lord through all those pages.
No, you just give me the page. I just want to put in the note.
Yes.
24 months.
24 months, my lord, would get in the compilation.
Page.
It starts at page 40. Second volume.
All right. Yes.
And then second and third, there is no problem, my lord. Second, serial number 2 is not a problem. It is the admission record of NIOS. And serial number 3 is the diploma, my lord. So therefore, this I challenge saying that 1, is it my responsibility to over and above what happened in 2017 to show that am I in service? And is that my responsibility? The only
In
thing,
which schools were you that time?
rural schools, my lord, we have experienced letters of
And these
inspection.
are all under the state government.
No, my lord, these are all private schools.
Private schools.
Private schools. Kindly see, I will just show one experience letter. I have put it in the writ
So
petition.
you want the state to go to the private schools and get these information.
Indeed, my lord. In fact, it is not really.
In short, this is what you are saying.
I will just modify my argument, my lord. I want the state should check the data they sent in 2017 because NIOS state had a MOU. The MOU is on record. The MOU said, state, please give me the name of all in-service teachers. If my name would not have
What
been
do in-service teacher means?
in-service, my lord, what happened is
In private schools
private-
as well.
in private schools only, my lord. If I was in government, then I don't need to really come here for a better opportunity. One of the example, if my lord would see at page 68 of the writ petition,
But in-service,
in-service meant, my lord, what happened is,
no, because this court is trying to understand
Yes,
that
yeah.
how can how can you expect the state to go on inquiring from all private schools and find out who are the teachers?
yes, the answer to that,
If any particular teacher is interested,
yes,
he has to produce those documents and show that he is in service.
yes,
The
Yeah.
schools are not under the state government.
yes. The answer to that is this, my lord. The exercise that was put in force in 2017 from Ministry of Human Resource and Development to the Education Secretary of the state and through this NCT was that the state will go to each and every district education officer, and this district education officer of the state will ask each school.
Where are those?
Yes, I will show those documents.
Let's go directly
Yes,
there.
Yes, my lord. Very well. Kindly have the second volume, my lord, of the convenience compilation, which I was referring to, my lord. It has directly come to page 47.
For one order of BPR of Supreme, and what that is BPR order of Supreme.
Yes, yes.
Page?
47.
Yes.
My lord would have, it's dated 3rd August 2007.
Yes, I have it.
And it is by MHRD to all the secretaries, my lord. It's addressed to the secretaries. Secretaries including the Secretary of State of Assam. Please see, my lord, the opening paragraph to understand that why was this done, my lord. This is regarding training of untrained in-service elementary teachers to the government-aided, unaided private schools. It is apprised that the amendment to the section 23(2) of the RTE Act to extend the period of such training to so-and-so has been passed by the Parliament. Further, it is reiterated that this will be the last chance to acquire the requisite minimum professional qualifications. Any teacher in the aforementioned schools who does not have the minimum qualification mandated under the RTE Act 2009 would not be allowed to continue in service beyond 1st April 2019, and procedure for dismissal shall be initiated against such teachers. Then my lord would kindly mark the next heading, action to be taken by states/UTs. Kindly see Roman 1, my lord. States and UTs will be responsible for ensuring that all in-service untrained teachers, government schools and private schools in the state and UTs acquire the minimum qualification required under the so-and-so within the proposed extended period. Please see 2, my lord. At the state and UT level, very, very important, a committee under the chairpersonship of the Secretary, Elementary Education, needs to be set up to monitor the progress and completion of training of all in-service untrained teachers at elementary level within the stipulated time period as per the amendment of the Act so-and-so. Then please see 3, my lord. States and UTs will also appoint a state coordinator for the state UT to facilitate conduct of the program and for continuous engagement with the MHRD and NIOS. Then, my lord, may kindly come to the next page. Please skip 4, 5 and 6. Kindly come to 7. Roman 7.
Yes.
All states should prepare a database of such teachers in their state. Please mark this. 7. All states should prepare a database of such teachers in their state. Please
Yes.
see 8. For creation of database of untrained elementary teacher of D.El.Ed, there will be an online portal of
Do you have a better copy of this? It's very,
I'm sorry.
it's not very legible. The copy that is there in my compilation.
There is a note also that would have come. Is this better?
Yes.
I am reading page 48.
Is
Roman-
this also a compilation? The same compilation?
Same thing. Another copy.
Should I then keep this?
Yes, but keep that. All these are inconvenience here. There's a note with the guide with the tab. We have given it to the LC.
Yes.
Yes, my lord, I was reading page 48.
Yes.
This is the initiation of the process, my lord, and Roman 7 was important.
Yes.
All states should prepare a database of such teachers, which is us, my lord, in their state, for creation of database, again, my lord, of untrained elementary teacher of D.El.Ed.
Yes.
There'll be an online portal of NIOS which will have the following options. Well, this is very, very important. Login/registration by the state coordinator. Login registration by the individual principal of the school. Lord may note there is no option of logging in by me as a candidate. I cannot log in.
This is for creation of
Database of us who are in service, my lord,
database of untrained
In service.
elementary teacher.
which is us.
There will be an online portal of NIOS which will have the following
Option. So the options to create this database at that time in 2017 was with two people. One, the state coordinator. Second, the principal of the school.
But the information that they are asking is not about the database or anything. They're individual to these people. They are bound to have their own appointment letters, their own salaries. These are individual concern. If somebody is serving as a teacher in any school, be it rural, urban, be it any private school, there must be an appointment order. There has to be.
My lord,
Otherwise, how the teacher has been appointed? It could be an illegal appointment.
yes. The answer to that is this, my lord.
And how can the salary not be given? How can it be given in cash?
My lord,
Generally, I don't know. These are things
Yes.
that is troubling the court.
Yes.
You have to
my lord,
clear all
yes.
this because the impression that is coming is that perhaps that is why I'm sharing.
Yeah.
That database is okay.
Yes.
But they are not asking anything for you to log into these databases and take out something and produce it. Those 9 documents doesn't talk about these.
The answer is this, my lord. My lord, kindly see it as an example.
You are trying to say it indirectly by saying that, well, the state ought to have known it. So
This-
therefore, the state should not have asked for these documents.
That is my first argument.
This is
That
kind
the
of
first
what you are
argument.
trying to
That
say.
is the first argument. The second argument is, if all these documents were told to me in 2017, my lord, because most of these schools after COVID has closed. Most of these schools don't exist today. If that time these documents were asked from me, my lord, I would
No,
have.
but the appointment letter would have been with you.
Yes, the answer to
If
that.
you had an appointment, if you are receiving salary, it would be you individual, it would be in your bank statement. You don't have to go after a school for collecting these documents.
The answer is this, my lord. Most of these schools are in rural parts of the state, my lord. I till today, forget 2017, till today get salary in cash, 3,000 rupees.
Is that
a month.
correct, Mr. Soikia? That position only.
Whether
I'll
it is-
hear you in
no, no,
detail.
Whether it is cash or or to bank transfer does not make any difference. Salary is salary.
But
No,
That slip, it can
there is a pay slip.
as a pay slip.
before asking me, my lord, and this is the proposition of law that I'm trying to frame, these 9 documents which they have asked from me, my lord, the first thing they should have shown, my lord, in the counter is that these 9 documents are mandatory for a private school. That is the first question. Without the state making it mandatory for government schools, I understand.
You are saying that without any application of mine, they have
It's arbitrary, my lord.
they have just
It is arbitrary.
imposed these conditions, these documents, which are absolutely impossible for you to
Indeed.
produce. This is
Indeed.
what you're trying to
Indeed.
say.
Indeed.
In a way, they are trying to
Eliminate us.
deprive you.
Eliminate us, and that has been the trend from day one, which I'll just show. So therefore, what I'm trying to only thing that is missing is a selfie in a school, my lord. That is the only thing missing. That
What?
a selfie in the school with me teaching, my lord, is the only thing they could have added to this. But please consider these daily workers, my lord, with all my humility, my lord. But these daily workers, the masons, we have them for one day, my lord. If we have to ask for their experience certificate, my lord, that they were getting 500 rupees a day or 400 rupees a day, and we are asking for their experience certificate, the first question that I need to ask myself is,
They are assistant teachers. We are
no,
talking
they're assistant
about.
teachers today.
The
Today we are-
teachers.
Yes.
The teachers. They're
They-
not some
No, but-
daily laborers, Mr. Counsel.
My lord, they may not be daily laborers, but the point that the reference that I'm trying to draw is they are unregulated. That's the most important part. Let the government show one notification by which they say that every government school should have a school management committee, every private school should have a school management committee.
These documents indicate that now the effort is to ensure that they regulate all this.
My lord,
Perhaps they are now trying to regulate.
my lord, in my humble submission, I will try and show that still they are not doing it because they're asking me. If they go to the private school and say that, boss, you should only give salary in cash, please have the pay slip.
What do you mean by boss?
The government goes, my lord.
Please
referring
don't
to
use these kind of words in the court.
I'm referring to the government, my lord. The government
Don't
goes.
use these words in a
Very well.
constitutional court kindly.
The
Yes.
government goes and tells all these private school principals, my lord, that I want to regulate all these 7 things, my lord, and says that now onwards, any teacher you keep, you should give an appointment letter. Any teacher you keep, you should have a school management committee. Any teacher you keep, you should give a pay scale. At least one document they should show they've done it till today. If that is not
All
mandatory,
right, noted.
yeah, then please come. I was at 48, Roman 9, my lord. 9 is very, very important.
Yes.
State coordinator, please mark this, will enter the entire database of untrained in-service teachers in private and government schools on the portal, especially prepared by NIOS for this purpose. The state coordinator has to enter. This portal will also be utilized to monitor the progress of training in each state /UT. Now, 10 and 11 is most important, my lord. For teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school. These certificates will be collected by the state /UT. Please pause there for a minute. In 2017, what is laid down, my lord? This is the first order of recognition, my lord, where the MHRD introduces this entire concept. I will show that how these things are being kept as it is.
Is this 3rd August 2017
17.
document communicated to you?
Me, to the secretary of the
To
government.
the secretary?
Of the government, my lord would see on 47, it says, dear secretaries.
Yes, that's I've seen. And to principal secretary and secretary education, all
Yes,
states and
it is
UTs.
given to all the secretaries, including the state of Assam.
And the subject matter here is regarding training of untrained in-service elementary teachers.
Yes,
That is the
Indeed.
subject matter.
indeed, ma'am. This is the first time when the communication started. I'm showing these documents. All of these have been referred to, interpreted by a subsequent Supreme Court judgment, which I will show for Uttarakhand and West Bengal. And therefore, change of rules of the game comes into picture, a 5-judge bench of the Honorable Supreme Court, which says that the rules-
You've been referring to the change of the rules, but what rules have been changed?
the rules have been changed is this, that
Because this is not the terms of the advertisement. This is not the term of the recruitment also. This is some internal communication of the secretary, of the additional secretary
Yes.
to the secretaries of the state.
Yes,
This is not to you.
the answer to that
There is
is
no
this.
rules here.
Yes, the answer to that is this. The advertisement says that I have to be eligible as per NCT.
So we'll go there, and
I
as
will-
per NCT, it is 24 months.
As per NCT, it's 2 academic years.
24 months.
2
No.
academic years.
So we'll go there.
Yes.
We'll go there. If there is any change in that, we will see.
Yes, yes.
One
I will-
second. I'm just noting down this.
Yes, please.
1 second, please. In service elementary teachers. What is this RTE Act?
The Right to Education Act. Right to Education Act.
এইখন act উলিয়াই থব না? So this particular document at page 47 has reference to section 23(2).
Indeed, my lord.
What is section 23(2)?
This 23(2) was an amendment that was brought in, that whichever teacher has not taken the minimum eligibility qualification to continue as a teacher or get appointment as a new teacher, the time was extended till
31st March
19.
2019.
19.
Okay.
And I have completed before 31st March 19. So I was at 48, my lord, Roman 10. And then please see Roman 11 also.
11.
Yes.
Yes.
Once the above information, which is the above information? The experience certificates. Once the above information is provided to the state coordinator, by whom? The principal. Then NIOS will provide the following to individual principal for entering into the system, that is school code and password. Once the school principal receives the password and the school code sent by NIOS through SMS Then the school principal will log in into the system for online registration of the untrained teachers. So I am the untrained teacher, I am the end. In this entire flowchart, my lord, I come at the end. Everything to train me is beyond my control, if I put it in this way, is beyond my control. If the above flowchart is completed, only then would I be eligible to be part of the course, is what the secretary, this would now be converted to a recognition order. I will show that. Therefore, this is very, very important. And then please see, my lord, page 49, the next. May I read, my lord? 49?
1 second.
Sorry.
I use meanwhile उपयोग लग रहा है
Foundation. The foundation was experience certificate from principal, not to be submitted by me. The state needs to collect it from the principal. That was the mechanism at that time. On that foundation, could I get this course? Then please see 49, the next very page. The MHRD reaffirms that
40?
49, the very
Yes.
next page. Is number 4.
Yes, timeline. Yes.
Timeline. The timeline which is most important is the third last one, my lord, by 20th August 17.
Yes.
States and UTs will submit complete database of all in-service untrained teachers in government and private schools to NIOS. NIOS is that institute. The cutoff date for me to be in service was 10th August 17. 20th August 17, the state and UTs need to give my name at that time to NIOS that these are the people I want you to be trained. I want the NIOS to train. And all states did this, my lord. All states went ahead and gave their names. And then please come, my lord, to the recognition order, which is, so this communication, my lord, ultimately culminates into a recognition order by which my course was recognized. Please come to page 63.
Yes.
22nd September 17. This is by NCT, which is the nodal agency, my lord, for deciding the qualification of all teachers across the country. The RTE Act says so.
Yes.
And then my lord would see the reference which has been given to the communication which we were just reading, my lord, at the fourth paragraph from top. In view of the above mentioned directions of MHRD, Ministry of Human Resource Development, under section so and so, the letter dated 22nd September 2017, following instructions of NCT regulations for ensuring that directives of, so it was a directive, my lord, that letter that we were reading, for implementing the amendment to the RTE Act 2009 are duly fulfilled. Please see from 1 onwards, my lord.
Yes.
Any provision related to online submission of the application on the NCT application portal? Any provision related to the duration of program so as to reduce it to 18 months instead of 2 years, and the requirement of 6 months internship to be subsumed.
So what is this letter 23/9/2017?
23 9, 2017, my lord.
A letter dated so and so to the following provisions in the NCT
22
for
9,
ensuring that the directions of so and so
which we just read, my lord.
That is that letter.
22 9
That is the 22
Indeed.
9.
by MHRD, which was a directive given.
Page 47.
47, my lord.
All right.
Starts at 47.
Okay.
And then the most important part of this is, my lord, kindly come to 65. Everything regarding the course is given, my lord. And 65 is important.
Yes.
Roman 8. This program shall be only for those in service. Very, very important. Untrained teachers in government aided private unaided schools appointed on or before 10th August 17.
And these program is basically training of these teachers,
It's diploma in elementary education.
Diploma and
Elementary education. That's the only thing. Because the NCT said that any primary school teacher should have diploma in elementary education. There were teachers who were working at that time when this amendment was.
and they did not have this.
They did not have. They
Diploma.
had B.Ed. They had some equivalent course, but
you are entitled to get it from any open university,
I am entitled to do it as a 24-month thing.
which can be also 18 months.
No, as a 24-month thing, I can do it from any open, from Jawaharlal Nehru, etc.
Okay.
But as an in-service teacher, this was the only portal one-time scheme. It is
That
not
is 18 months.
18 months. It was a one-time scheme.
This is under that this particular notification, right?
This particular notification is on the basis of the directive of MHRD.
This
is the
is
recognition
any
order.
provisions related in the duration of the program so as to reduce it to 18 months
Yes.
instead of 2 years and the requirement of 6 months internship within the duration of 18 months.
So these are all the part of the recognition order for my
What
course.
does it say number 2 at page 63?
It's 63.
For implementing. Now, where have they implemented? Where have they amended the RTE Act?
They have amended the RTE Act, which we read, my lord. Earlier, the date to complete this recognition was 2015.
Okay.
Then they made it 2019.
Okay.
So therefore, they say here that because, so it was like this, my lord, because we were already in August 17. The eligibility had to be completed, or the minimum qualification had to be taken by March 19. The duration from September to March 19 was only 18 months.
18 months.
So therefore, what came out at that time, my lord, that because these teachers are already teaching,
so therefore the
that
relaxation.
6 months of internship will be within those 18 months.
A kind of relaxation.
Relaxation, kind of submerging. That is what the word is used.
Anyway, this
Yes.
is settled.
This is settled. And therefore, prior to the present recruitment, my lord, whenever the government has taken people like me, they have never asked for any of these documents. That's very, very important. This is not the first recruitment where I am being appointed or I am being considered. There were recruitments in 2020, 19, 21 by the same very state. And I was considered. People like me are working. None of these documents were ever asked for.
Okay.
Because the foundation is this. Their reliance is on the Supreme Court order, which I'll show does not really come from the Supreme Court order. So I was reading 65, my lord.
Yes.
At 65, my lord, as I said, this program, Roman 8, this program shall be only, that is very important, for those in service untrained teachers appointed on or before 10th August 17. So this 10th August 17 in the Supreme Court order comes from this. And all the present petitioners before my lord have the experience certificate from the principal, which was required at that time, of being in service prior to 10th August 17. It is annexed to the writ petition also. All of us have it. There is no quarrel about that in any manner whatsoever.
That's an admitted position.
That's an admitted position. And then, see, my lord, another communication by MHRD to the state at 69. My lord, the earlier recognition order Was of September, my lord, and 69 is October 17. Again, dear secretaries by MHRD. Please have para 3 of this, my lord.
Yes.
It is reiterated that the verification of all unqualified / untrained teachers registered. So first was documents to be given.
Verification.
Then there is a verification also at NIO's portal should be completed by 30th October 17.
30th,
So,
10,
17.
70.
Now, for a minute, if I have to argue against myself, Lord, that if a state has not done this verification at that time, for whatever reason, my lord, there could be two reasons. One, they have done it, one, they have not done it. Can 8 years later, my lord, without a statutory backing, that's very, very important. Without a statutory backing, my lord, can they reopen this verification when the entire premise of me doing this course was state's information, state's database, and verification by the state at that time? There is absolutely no averment in the counter or the reply filed by them that what happened to the verification that was done at that time? What happened to the database that was done, given at that time? There is nothing. I understand, my lord, if their case was that, see, we had given the names, we had verified at that time, but your name is not found. I understand if they raise that as a ground today. That we have checked our database of 2017. All the petitioners who have before this court, their names are not found in that database. Even then, I can have a counter argument to it that I couldn't have done the course if you didn't give my name. But there is no averment which I will just show. So whatever happened in 2017 as a part of the state's activity, the state in their defense is silent about it.
All right.
Then please come, my lord, page 70. See how foolproof, my lord, in my humble submission, this entire scheme was made. Please see page 70.4, para 4. The NIOS and state government would need to sign a MOU for which a pre-vetted format of the MOU is enclosed. In addition, state would also be required to organize workshops in November, December for the learners of which norms and remuneration is given at an extra so and so. And then see 72, my lord, the MOU. The MOU starts at 71. That how every state had an MOU under which all this had to be done and was done. 71, my lord, is the format of the MOU. It is between NIOS and Department of Dash. It will be the specific state, my lord.
Yes. All right.
So this is one thing in this, my lord. 72 is important. 72, clause 1 and 2 are important, my lord, of the MOU, which the state would have signed, and it is not on record today, but please see clause 1, my lord, of 72. Work in close collaboration with the Department of, it will be Assam here, to open the study centers as per so-and-so. 2 is most important, very, very important is 2. Enroll the learners with NIOS after necessary documents are verified by the Department of so-and-so.
Yes.
So the responsibility at that time, as I said, was on them, my lord. And then my lord would kindly see that how, so these are the documents which I wanted to show. After that, my
These
lord,
verification is only for
in service.
huh?
In service. Whether I'm
Correct,
in
but
service.
to ensure that whoever these teachers are working wherever, whichever unneeded government schools, as unneeded private schools and all, are also having the due qualification of
Indeed.
diploma. This is the purpose, isn't it? These verifications.
This verification is for this purpose.
Is to ensure that those teachers have
Are actually working there. As simple
no,
as.
not working there. The
Hello.
fact that they're having these qualification, I think qualification is important,
But unfortunately,
isn't it?
documents that doesn't come in. What comes in from the documents?
No. The verification process is otherwise to ensure that they get that training.
Yes, the verification.
Correct.
We just let us read it once again, my lord, for my convenience, or in fact, my lord's convenience. Let us read it once again.
No, this whole process started from that first document you showed.
Indeed,
This is all for the training purpose.
training of 18 months.
Training of 18 months. Now, this purpose is for what? To ensure that these teachers who are working in these private schools
Yes.
have the requisite diploma training.
Indeed.
Correct.
Indeed.
So basic purpose is for their qualification.
Indeed. Indeed, that is one purpose. There is also a second purpose. That someone who is not working, someone who is actually required to take a 2-year regular course should not come in here. That was another purpose. Because everywhere the emphasis is untrained in-service teachers. That's very, very important. The emphasis is not on any teacher. It has to be untrained in service. So this
So
verification
whoever is already doing that training will not come in here.
will not come in here, or
So these are the reasons why that verification is required.
a person who was not teaching but wanted to take this course should not come in. That is also another
Followed.
very important aspect.
Followed.
So therefore, the provision is, or the clause is, enroll the learners with NIOS after necessary documents are verified by the Department of the State. Documents whether I am teaching in that school or not. In service was the only thing to be done by state. And then my lord would kindly come to the writ petition now. Now I wanted to show that there is a Supreme Court clarification. The Honorable Supreme Court then implemented its own order. Let us please see that. That will just throw some light upon, because the entire argument of the state today, which they will canvass before my lord, is Supreme Court empowers us to do this. And I will show from these orders, my lord, that the Supreme Court rather, in one of the cases of BTR, my lord, has said that please go ahead and appoint. There is absolutely no question of verification. I will show that order, my lord.
There's an apex court order.
Apex court order saying that please directly appoint them of June 2025. So please now have.
Where is that order?
This is the last in the line, my lord. There were 2 orders prior to this, but let us see this first because this concerns state of BTR actually. Yeah. BTR. Lord, may I read?
Yes.
These transfer petitions have been preferred by the petitioners who have preferred writ petition before the High Court seeking appointment to the post of assistant teacher on the strength of 18-month diploma in so-and-so, conducted by so-and-so. The basic proclaim was the order passed by this court on so-and-so, and the clarification issued by this court from time to time. Mr. Ankit Roy, Learned Standing Counsel appearing for the state of Assam, fairly states at the outset that similar writ petitions preferred by other candidates remain pending, and those have been decided by High Court granting relief similar to the ones which the present petitioners have prayed for. Then please have the next, which is very, very important, my lord. Learned Counsel appearing for the state of Assam prays for sending the matter back to the High Court. However, considering that the similarly placed petitioners have been admittedly being granted relief, which they have been prayed for, it would be necessary to relegate it unnecessary to relegate the petitioners to the High Court. Therefore, we dispose of the present petitions by allowing the writ petitions preferred by the petitioners in terms of the orders passed.
Which is that other the decision of the High Court that has been referred here.
And then please see the last part. In addition, it is directed that since the petitioners have already participated in the counselling, they shall be issued appointment letters, orders based on their merit position / result of the counselling.
But where it is said that without insisting on verification of the documents,
Yes,
where is that?
that will come, my lord. There are
No, that is not there in this order.
I will
You
show-
had given the impression that it says without insisting on the verification. If I heard you correctly, I
Yes,
don't
yes,
know
it
what
does.
Mr. Saikia had heard, but
Yes.
I heard that. Yes.
The distinction is this, my lord. This is for BTR. For Uttarakhand and West Bengal, the Honorable Supreme Court says verify the claims. I will show that. Here, there is no concept of verifying the claims. They say they shall be issued appointment orders based on the merit position. Why is the distinction, my lord? Once we see those 2 orders, it will become clear. Can we just have those 2 orders in the next 5 minutes? It will become clear that why those 2 orders cast upon a verification. Here, there is no verification required as per the terms. In fact, they are proceeding ahead to
Mr.
issue.
Counsel, what is the arbitrariness or illegality? On what basis? Because it is the state who is deciding the terms and condition of the recruitment. They have issued that circular. What is your ground, basic ground?
The basic ground is this, my lord.
They are the ones, they want to verify the credentials, they want some testimonials. What is wrong in that if they're asking? Whether you have whether they had done a similar exercise earlier during the training part or not, that is not the question. If you had been teaching in a school, you should have had these documents. They only want you to produce those documents. What is wrong?
The answer is
This court is exercising extraordinary writ jurisdiction. The state, in order to ensure, because ultimately this is for the benefit of the larger public interest is also involved. It is not per se only the teachers. So many things are involved. The state wants to ensure everything, and they are asking for certain documents. What is wrong about that?
The answer is
Ultimately, that has to be
Yes.
decided,
the
isn't
answer
it?
is this, my lord.
Now, this training and all understood. At that time, verifications have been gone into to ensure that these teachers who are in service receive these training, that 18-month benefit, who are already in training will not get it. All understood. That has been done. That's a different exercise. Now, as per this is concerned, for this particular recruitment in question, they say, after, and that also after the Supreme Apex Court's decision, which says if they are in service so and so. Now, in order to verify whether you were in service to that particular cutoff date, they want these documents.
The answer is this, my lord.
Just because you are, according to you, the how many petitioners?
171.
These 171 petitioners does not have it. That is why you are saying it is only because of that, isn't it?
No, it is not really because of that, my lord. There are multiple more things that I will show, my lord. The point that I am trying to make is this, my lord. State at best, my lord, kindly. Allow me to frame.
When was the first advertisement issued?
26 December 2023.
26.
December 2023.
I'm sorry if I'm breaking your flow.
Not at all, my lord.
It's just that I have this habit of
Not at
asking
all.
questions, so don't get intimidated.
Not at all. This is my duty.
Please give me the date of the
26 December 2023.
26.
December 2023.
23. And the Apex Court judgment came on when?
The Apex Court judgment of clarification comes on 10th December 24.
Before. And the circular?
The circular, the present impugned circular, my lord?
Yes.
Impugned circular comes on 17 June 25.
17?
June 25. There is one more date which will be important.
Yes,
my lord.
please.
The Apex Court clarification comes on 10th December 24.
10?
December 24.
10 December 24 you have given. That is
But
the Apex Court judgment you said?
clarification.
Yes, yes.
But it is made effective from 28th November 23.
20?
8th to 8th
Yes.
November 23. It is made effective from that day.
23.
Yes.
Right. So therefore this
Advertisement
is covered.
Yes. Now the question that my lord put to me, that if state wants to verify etc. these documents, my lord, in my most humble submission, my lord, state has the power and the ability to fix the eligibility. That too relying upon the NCT guidelines. The NCTs decides the eligibility of an assistant teacher, which is common across the country. The state uses those NCT regulations to fix the eligibility. The question really is, my lord, am I fulfilling that eligibility criteria? Yes. They can have 10 more things to ask me on the eligibility criteria. Having these 9 extra documents, for which, one, they need to describe the source of power, my lord, because they are Article 12 state. They need to
Source of power for what?
for asking these 9 documents.
The Apex Court decision?
Because the Apex Court does not say that verify the in-service status.
One of the condition is
Yes.
One of the condition is
that I should have been in service.
yes.
The in-service.
Now the Apex Court doesn't have to write everything in here. That now you start a verification
Yes.
process. You start asking for ABCD
Yes.
documents.
Yes.
That it did not spell
It will not
everything. Anyone who read that order will understand these are the two conditions.
Therefore,
now, how the state wants to satisfy these two, whether these two conditions have been fulfilled or not, it is their prerogative.
Yes.
What is wrong in that?
Answer to that is
They are doing it. They are following the order of the Apex Court.
Answer to that is this, fellow.
If they don't do that, another batch of writ petition would have been filed, saying that they are not verifying. Without verification, they are allowing it. That could have been also a situation, isn't it?
Much possible.
Mr. Karla?
Much possible.
Yes.
But the way this clarification order has been interpreted by the apex court, again, for Uttarakhand and West Bengal will throw some light upon the query that my lord posed. That is point number one. Point number two is it is not just the state of Assam which is implementing the Supreme Court's order. There are at least 8 states
Other
plus KV implementing the Supreme Court's order. I had the good fortune of assisting in almost 7
Now,
of
in
those.
those,
Nothing.
they are not.
Zero. I have example of one of that. KV, my lord, Kendra Vidyalaya,
Now,
Sangathan.
just because they are not insisting doesn't mean that the state of Assam is precluded, Mr.
My
Counsel.
lord, the state
They are
of-
trying to be more vigilant.
The answer is this, my lord, that if any of the Honorable Supreme Court's own interpretation can show, which they have interpreted later, that you please verify the in-service status over and above the experience certificate. That's very, very important. All these writ petitions, etc., that were filed, because I had the opportunity of filing them, my lord.
So you want to say because the petitioner has the
Experience certificate, all of us have it.
which was one of that condition in that
Only
earlier
condition.
only condition.
Yes.
Therefore, that is sufficient.
Sufficient. There can't be more things to it.
Noted.
That is my
Noted.
primary argument.
Noted.
That I am producing, if I don't produce that certificate as an in-service thing, I'm out. Absolutely no quarrel on that.
Noted. You please give me the reference of these pages of these experience certificates.
Indeed, can I just show one?
You
for,
can give it that later on. You can
For example,
give
can I
a
show
short
one?
note indicating all this
Very
later
good.
on.
We have made a written submission. Can I just show one as an example?
Yes, yes.
Please see 68, my lord.
Yes,
for the
just
first,
read it.
68 is by Christo Jyoti High School, Post Office, Golaghat District, Golaghat, Assam. Says experience certificate issued by the principal, my lord.
Page.
68 of the writ petition, the fact volume. And for each of the petitions I have produced. '68.
Yes.
Christo Jyoti High School, my lord. Post Office,
Date is blank.
It's written on the bottom, my lord, 23/6/25.
Where?
On the bottom, above the signature, my lord, by the principal.
Yes. Why that date column is blank?
That the principal would know on this point. But in my humble submission, my lord, if we get on to the fact finding, my lord, my lord, but see,
Yes.
please see this, my lord. Experience certificate. It is hereby certified that Mr. Dilip Bhandari so and so has been working.
All right.
It is not their case. This is very, very important.
All right. I've taken note of your argument.
I'm
You are
going a
saying
step
that you
further.
have the experience certificate. Therefore, there was no occasion for the state to ask for further documents because anyway, a verification has already been done.
I'm going a step
Correct.
further. It is not also their case that these experience certificates are
Not
fraudulent. Are fraudulent. It is not their case. It is not their case that we have looked into these experience certificates. We have checked with the concerned school and they have said no, they never issued such certificate. So the correctness of my experience certificate is not in question because they have not disputed it. That's very, very important.
Have you been not allowed? It is your apprehension that because you don't have these documents, you will not be allowed to participate in the
The
further
list has
process.
come yesterday, my lord.
There you are not. You're not there.
Most of us have been withheld, and most of us have not been considered, despite being higher on merit. The people that are featuring in the merit list
Withheld perhaps because of verification.
withheld because of the fact that the case is pending.
There are some back office verification is
Sorry,
there
there is.
are some back office verification. I have the complete figure. I'll place it, Lord.
And then another example, because my lord asked me the date, please see 100 also. For every
Right, that's all right. I've understood.
so
Joining date is there.
joining date is also mentioned at 100. So for each, and I understand, my lord, a supporting document or a subsequent document would be relied upon if there is a credibility doubt. Please take my words, Lord. Credibility doubt to the main document, to the foundation document. It is no one's case that there is a credibility doubt to the foundation document. Or the supporting document in any government scheme, my lord, or any government recruitment will be required if the first is not available.
All right. Next point, please.
Then, my lord, will come
You
that.
don't have to repeat the point. I've understood.
Very well, my lord. Please come to how the Honorable Supreme Court applies its own clarification. Please come to writ petition, page 585.
Page
585. This is March 25, my lord. I'll take maximum 20 more minutes now and I'll.
No, it's all right. Yes.
Page 585, my lord would see. This is the Honorable Supreme Court applying its own clarification for Uttarakhand. We'll have to just go through this judgment, my lord. This will throw some light upon whether this in-service concept can be looked into again. Kindly have para 1 at page 585, my lord, to understand what was there before the Honorable Supreme Court. May I read, my lord?
Yes.
By way of this application, the applicants have approached this court for a direction on the respondent, which is state of Uttarakhand, to permit the applicants who are holding 18 months D.El.Ed qualification from NIOS under the open and distance learning mode to participate in the ongoing counselling process and to subsequently be appointed to the vacant post in the ongoing recruitment. This case has a checkered history.
What is counseling process? That is that training process.
The counselling is the state recruitment that was ongoing in Uttarakhand. So like the state recruitment is ongoing here, my lord, there also state recruitment was ongoing with
And
this.
there is some counseling process.
Yes, counselling. This verification appointment is a part of the counselling. So together they put it as a counselling process. And now 586 gives the entire history of the documents we read, my lord. Everything
Yes.
is put in here from para 3 onward.
Read.
It will be important, my lord.
Read.
In 2017, an amendment has been carried out to the Right of Children to Free and Compulsory Education Act 2009, wide which clause 2 was inserted in section 23 of the said act. The Right to Free and Compulsory Education Amendment Act of 2017 was made retrospectively applicable from so and so. It was provided that every teacher who had been appointed or was in service as on 31st March but did not possess the minimum qualification of 2 years as laid down under the subsection 1 of 23 would acquire such minimum qualification within 4 years from the date of commencement of the Amendment Act, which was 15. Then please see para 4. In view of the provisions of the second proviso, to subsection 2 of 23 of the RTE Act, MHRD, this is the letter we read, my lord, the first letter, had issued a letter of 3rd August 17 to all the Secretary of States and Union Territories directing that all teachers in government school must possess minimum qualifications as mandated under the RTE Act, and a last chance was being given to all such teachers to acquire minimum qualification till so and so. Failure to acquire the said qualification within the stipulated period would result in dismissal from service. Since the time gap between 31st March 2015 as provided in the 2017 Amendment Act and 31st March 2019 as specified in the direction issued by MHRD was 18 months, the NCT issued a recognition order of 22nd September 2017 for conducting D.El.Ed program through ODL mode by NIOS through Swayam portal of MHRD for in-service untrained teachers at elementary level working in government aided and unaided private schools.
What is ODL mode?
It means online distant learning.
Yes, please.
The said recognition order.
Online distant learning. All right.
This
Yes.
is the recognition order we read, my lord. Then please see, we can skip para 6, my lord. That may not be of relevance. Kindly come to page para 7.
Which is para 6 is which one?
Subsequently, the state of Uttarakhand, that we can skip because that is relevant to specific to Uttarakhand. That is not required to be gone into. What is next important is, my lord.
Let's read the whole order.
Very well, my lord. Subsequently, the state of Uttarakhand issued district-wise advertisements for the post of assistant teachers in primary schools in accordance with Uttarakhand Government Elementary Education Teacher Service Rules, for short 2012 rules, framed by the government of Uttarakhand, which provided that for being eligible to appointed as a teacher, it was necessary to have a diploma course of 2 years or equivalent. Initially, on 15 January 2021, the Secretary Government of Uttarakhand issued a letter to the Director, Elementary Education Uttarakhand, to permit such candidates who passed 18 months diploma of NIOS through ODL mode to apply for the post of assistant teachers against vacancies issued through the aforementioned district-wise advertisements. This was done in compliance with the letter dated 6th January 2021, issued by NCT to the Chief Secretaries to all the states and Union Territories, requesting them to consider all those candidates who had completed D.El.Ed course of NIOS through ODL mode. However, shortly thereafter, upon realizing that 2012 rules did not recognize the 18 months diploma through ODL mode from NIOS as a minimum qualification for eligibility, the government of Uttarakhand issued another communication dated so-and-so, whereby its earlier letter dated so-and-so was withdrawn. Then please see para 8. The aforesaid communication dated 10th February 21 was challenged in a bunch of writ petitions before the High Court of so-and-so. Why Uttarakhand is not considering their claim. It is
them in accordance with law.
indeed. So therefore,
There is no dispute.
there is no dispute. So therefore, here the claims are to be considered
Yes.
qua the 10th December 24.
Yes.
10th December 24 says you have to be in service.
Yes.
In service concept as in August 17 was you should give the experience certificate. So this exercise, my lord, was completed and those Uttarakhand teachers have been appointed. On what basis? Only one document, which was the foundation, which is the experience certificate. To the best of my knowledge, my lord, if I would submit, unless there is a gate opened that in addition to what was sought in 2017, you can ask for whatever you want. How can the state read between the lines?
All right, I've understood. Anything else?
Yes. Then there is one more judgment because that was the defense taken on the day of issuance of notice by the state. I will show you that, my lord. But please see this one judgment. This is for Uttarakhand. I read. The next is for West Bengal.
Yes. Page
This starts, my lord.
595.
It starts at 597. Just 2 pages I want to show in this, my lord. The entire judgment was on similar lines, but 2 pages would be important.
Yes.
If my lord would first have
Yes.
page 624. The direction.
Yes.
Direction 6 is important. We
Yes.
direct the respondent authorities to consider the candidature of such of the
Yes. Same.
So
There's no dispute to this.
there's
And that who on verification are found to satisfy the eligibility criteria
indeed.
shall be appointed within a
Now,
period
what
of
is
3
the
months from today.
Yes. What is the eligibility criteria? That is very,
Same,
very
Uttarakhand and West Bengal, the direction of the apex code is same.
Slightly.
That as per that clarification, if they are entitled, and this in fact emphasized on verification as well. In the first judgment, the word verification was not there. If the petitioners are entitled, then here it is added after verification.
kindly
Yes.
pardon me.
Now
for
you
reading.
see the problem is here.
Just give me 60
The problem is here that the state has devised its own way of verifying.
There's
And they have asked for few documents.
kindly pardon me, my lord. I would want to read this line
Yes.
once again.
And that appears to be in line with the judgments of the apex court.
Well, kindly pardon me. I will want to read it once again. Please read it with me, my lord.
The entire, it has to be fair and transparent. They are trying to adopt a fair and transparent method. What is wrong?
Well, kindly have it with me once again. I'll be able
Yes.
to. I have the confidence that I'll be able to satisfy, my lord.
Yes.
Please see Roman 6, my lord. We direct the respondent authorities to consider the candidature of such of the appellants who were in service as on 10th August 17 and who on verification are found to satisfy the eligibility criteria.
Yes.
Not the verification.
Eligibility
Yes,
criteria,
yes,
which eligibility
Yes,
criteria?
please come. That is the question. Please come.
The eligibility
Yes.
criteria is already there on
No, no,
10th August order.
No. The eligibility criteria is at para 10. Please see 605.
Para 10.
605. This
Para
is the
10.
eligibility criteria. And the present eligibility criteria, I'll show, my lord. I have no problem in verifying the eligibility criteria. That's the point that I'm trying
All
to
right.
draw.
Para 10.
This is Shri Gupta is appearing for West Bengal, my lord.
Yes.
It is submitted by, this is the eligibility criteria. It is submitted by Shri Gupta that not only a valid diploma, but also other requirements such as clearing TET, teacher's eligibility test, in terms of recruitment notification dated so-and-so, issued by so-and-so, West Bengal Board of Primary Education, my lord, have to be fulfilled so as to be considered for appointment to the post of a teacher in the school. It was
So
how
in addition to diploma, the other requirements
diploma.
also.
The eligibility is this.
All right.
And the eligibility has to be seen in my advertisement, my lord.
So it was therefore fairly submitted by the Learned Senior Council that such of the appellants who fulfill the eligibility criteria in terms of prevailing recruitment notification can be considered for appointment.
Indeed. And please see the recruitment notification in the present matter. Nothing like this is mentioned.
Where is that notification?
Yes, ma'am. Kindly have
Eligibility criteria?
this one. Please see 54, my lord. So 54.
Yes.
Oh, this is the advertisement. Just 1 second, my lord.
This is what? 54
This
is
is the
what?
impugned notification.
This is a circular.
This is the impugned notification,
Yes.
my lord.
Where is the
I'm showing the advertisement, my lord. This one. Please see 574.
5?
74.
574.
Indeed, my lord. $574, my lord, is the advertisement.
26 December 23. Yes.
Indeed, my lord. And then please see the eligibility criteria, which is mentioned at 575.
1 second. Page?
575,
Yes.
para 15.
Para 15. Yes.
Eligibility criteria for LP schools as per Government and Department of School Education. Notification dated so and so.
Yes.
Assistant teacher for lower primary is the second column, my lord. Category of post. And
Yes.
please see the essential qualifications.
Yes.
Higher secondary senior education with at least 50% marks.
Yes.
And 2-year diploma in elementary education.
Yes.
And Assam TET or Central TET.
Yes.
And non-essential. So they have given essential, which is the first 3. And they have given the non-essential ones.
Yes.
Where does any of these 9 documents
Hmm.
find place in the eligibility criteria is the question that I put to myself. The eligibility criteria, I repeat, my lord.
No, Mr. Counsel, those documents are not for eligibility.
No.
Those documents are only to verify whether you were on service on that particular cutoff date, if I have understood it
Indeed.
correctly.
Indeed.
Subject to correction, of course, but it appears that those documents are in connection with the Supreme Court's order.
Indeed.
That
So
is not.
therefore, the power
Yes.
and the scope of verification is limited. Let us see the Supreme Court order once again. It is limited to verifying the eligibility, not verifying whether I am in service or not. Let us see that order once again. Please read it with me once again.
Which order? The 10th?
The Honorable Supreme Court's order
The
of
10th?
March 25 of West Bengal. Page 625.
That I've understood.
Are-
That I've understood. That is in context of that case.
None of
I've
this-
understood, Mr.
Yes.
Counsel. Yes.
Even
Next,
in
any
Uttarakhand
other
case.
point?
Yes. Even in Uttarakhand's case, my lord.
That I've understood. Any other point?
Yes.
In addition to all this?
Then please see, my lord, how has one of the authorities, my lord, written submission? How has one of the authorities, my lord, KVS, followed the Honorable Supreme Court's order, and what have they asked for?
So, Counsel, that is not material. If somebody else is not asking something, that doesn't mean the others are precluded. Is that some kind of a precedent?
Because there has to be a source of
If another school or another authority is not asking for few documents, that becomes a precedent or what?
well, the question of parity would come in.
No, I have understood your point.
Please see
Yes.
in the convenient second.
I have understood that according to you that these documents were not required because firstly they were already available and all that they need to see is whether these persons were in service or not. For that the eligibility, the experience certificate itself is there, which is already there
which
on
was asked at
record,
that time.
which you have asked, we have all, and that you have given. That is sufficient. You don't need anything more.
In the second volume, my lord, of the convenience compilation, please have page 6 for a minute.
Page
6.
Yes.
Now, this is the table of all.
One second. In that compilation.
Compilation.
Yes, page
6, my lord. This is a table, my lord.
Yes.
This is a table of all, if I may read, annexure referred to in so and so, asked by the Honorable Members of Parliament, Shri so and so, teachers holding diploma in elementary education by NIOS. So, similarly placed teachers like me, my lord, in 35 different states, including the state of Assam, my lord. So, number 4 is Assam.
Yes.
And admission confirmed, my lord would see, is 1,33,878.
Yes.
So, in the entire country, my lord, the system of inducing me or having me in this process in this NIOS scheme, my lord, was common.
Was?
Common. It was common because of the MOU being common to everyone. Because the letter of MHRD being common. My lord put a question to me that because one state is doing, can you really draw an argument that because they are doing, why should this state not do it? Can there be a comparison to that? The answer that I'm trying to make in that context is this, my lord, that when the system of having me for the course was identical, the letters, communication, recognition orders, MOU was common, my lord. Plus, my lord, there is no express provision of law or order. Very, very important. It may be different to say, my lord, that the Supreme Court says, please verify the in-service status. I have no problem. Please verify. But the question really comes is, what was not really sought for as an experience or an in-service proof at the stage of relevant time can today it be sought? Because, my lord, therefore, I say that it is changing the rules of the game.
All right.
When an admission is sought, my lord, it is like this. Today, if my
Mr. Counsel, you don't have to repeat.
then please have, my lord, the affidavit in opposition filed by the government. I wanted to show three things from that. That what have they said in their reply?
An affidavit.
Opposition.
Go ahead. File to go.
Affidavit in opposition.
Yes. Which para?
Para 3, my lord, they choose not to give a para-wise reply.
No. Page.
Page, sorry.
Sorry.
Page will be 640.
640.
640.
Oh, नहीं फाइल क्यों लगी हो? देखिए रूपक देखिए actually यार part right? It यार part.
Oh, yes.
Yes, page
640. Para 3.
640.
Yes. After this, I will also want to show the ground because they don't reply to my grounds and my
640.
power that I asked for. Instead, what they say at para 3 is because my lord will have to decide as to the pleading also in my humble submission.
Yes.
At 3, they say that dependent, instead of giving para-wise reply to the writ petition at this stage, deems it appropriate to disclose the stand of the department against the relief sought for in the writ petition. However, the dependent craves leave of this court to file a detailed para-wise affidavit later. So, in my writ petition, I will show the grounds I have asked for their source.
All right, please carry on. Yes.
Please have para 5 now, my lord, at 641. I'm reading para 5.
Yes.
That before replying to the contention of the merit, the answering respondent raises a preliminary objection to the maintainability of the instant writ petition, as it is based merely on an apprehension and is therefore premature. In this regard, it is stated that in compliance with the order dated so-and-so and the directive Director of Elementary Education issued the impugned notification dated so-and-so, directing the candidates to submit the documents in support of their claim of being in service as on 10/8/17. The first thing here is, my lord, the Honorable Supreme Court's 10/12 order does not.
Mr. Counsel, can we just read now because you have already emphasized those points? No point in unnecessary reiterating all that. Let us just understand first what the state wants to say. You are placing the state's affidavit, so continue reading it. In your summing up of the argument, you can sum it up.
Very well, now please come to 643, last part.
Yes. 642, complete that paragraph you are placing.
It may not, if my lord,
It's not necessary.
not necessary.
All right.
Since we are short on time, my lord, I'll push it.
No, I do not want to cut you. I am ready to hear you.
No, my lord, I
But
understand.
there is no requirement of repeating the same things.
Very well.
Repeating is not going to help you. You clarify the doubts, that's all, and then place whatever you want to place. At the end of the argument, you can also sum it up if you want.
Please come
But
to
every
643.
second minute, if you start repeating the same thing, then you see the court loses track of the main issue. That is why I am saying. So follow the hints coming from the court.
Very
You
well.
place everything what
Please
the court wants.
come to 643, last 3 lines, my lord.
Yes.
The Honorable Supreme Court.
Where?
Last 3 lines at 643.
Last 3 lines from the bottom.
For this, no, there is no liberty further granted by the Supreme Court. This argument doesn't really stand.
Okay.
Then please come to next page, 644.
Yes.
At para 8.
Yes.
That the answering respondent humbly begs to state that there must be there must be necessarily be a reasonable and transparent mechanism to ascertain whether candidates were in service as on 10th August 2017 at the time they enrolled for and completed the 18-month diploma course. Employer has the discretion to find out whether the candidates have fulfilled the relaxation granted by the NCT and have they fulfilled the observation made by the Honorable Supreme Court in the case of Jaiveer Singh and others versus state of so-and-so. Order passed by so-and-so. The reluctance to furnish service particulars creates doubts regarding the eligibility, please mark this, eligibility, and runs contrary to the spirit of verification process. It is inexplicable as to why the petitioners are reluctant to furnish their service particulars, which are essential for ascertaining whether they were in service candidates as on 10/8/17 and had duly completed the 18th month's course so as to legitimately claim the benefit of the relaxation granted by NCT. Please mark two words here, my lord. Essential for ascertaining, and employer has the discretion. Then please come, my lord, to page 645.
645. Next page.
Yes.
It is stated.
645. They have reproduced the documents that are
Yes,
required, my lord.
yes.
The last document is the most
UDIS
problematic one because, as I say, that even till today, some of the schools do not have it because the government has not made it mandatory across the state. If the government had to make this core mandatory, and
UDIC records.
Yes.
What is exactly this UDIC?
because this is basically like an Aadhaar card for a school,
Hmm.
that you will have a unique identification number and you have to register with the government.
This is under some provision.
This is by the state, my lord. They are doing it as per their own powers under the RTE Act. But some states have done it, Assam has not done it. Whether it is mandatory or not mandatory is the first question that we need to ask ourselves before making it mandatory for us to give. Lord, I repeat myself. I'm sorry.
Understood. Yes.
Then please come. The last 5 lines at 645.
Yes.
However, the
Yes, Mr. Kalla.
Lord, may I kindly have page 36.
Page 36. Yes.
Kindly see short title and commencement 1-1 at page 36 bottom.
Yes.
These regulations may be called the National Council for Teachers Education, determination of minimum qualifications for persons to be recruited as education teachers and physical education teachers in pre-primary,
So this
primary.
requirement starts from here.
Starts from here.
And then those clarifications.
Yes, and then
All
the
right.
relevant is at page 37.
Page 37 also.
Yes, ma'am.
All right, we'll resume after lunch.
Just 10 minutes by clock I'll take.
It's okay. It is you who has been referring to some time constraint. This court has not asked you. You've been referring to the times. Mr. Saikia has also been very patiently sitting since you've started. He's not even gotten up once. So I don't know why you are referring to that. You will take 5 more minutes, 10 more minutes. You take your time. We are not stopping you.
Very
But all that this court is saying, that don't repeat your point. That makes no sense.
Very well.
Mr. Saikia, after lunch.